Hi everybody and welcome to the Legal Education. In these videos, I'm going to discuss essential element of a valid contract. This topic is very important for who are preparing judicial service or law student. Even for normal people, we must know the essential element of a valid contract. Now when you watch these videos, I want you to pay attention, watch all the videos, kindly subscribe to my channel so that you stay updated. Okay, well, let's get started. This question is very much important. So, define contract, discuss the essential element of a valid contract. Meaning, a contract is an agreement made between two or more parties which the law will enforce. There must be two or more persons are required to an agreement because one person cannot make or cannot enter into an agreement with himself. There must be two or more persons are required. Definition: according to Section 2H of Indian Contract Act 1872, an agreement enforceable by law is a contract. It is not difficult to find an example of contract in everyday life. In fact, you enter a contract daily without even thinking about it. You are entering an implied contract every time you make a purchase from online, shop at your favorite store, order a meal at a restaurant. Contract can be oral भी हो सकता है, written भी हो सकता है, imply or express, depending on what the situation. We will know enforceable. What is enforceable? What is the main source of enforceable? Enforceable की मतलब क्या है? Enforceable means you have a legal remedy. In case of breach of contract, you can file a case against him. कोई इंसान contract जो तोड़ता है, you can file a case against him. What is the main source of enforceable? It is essential element of a valid contract. If there is essential element of a valid contract, it becomes a contract. For a contract to be valid, it must be enforceable by law and must include the following essential given under Section 10 of the Indian Contract Act 1872. The first one is offer and acceptance. To constitute a contract, there must be an offer and acceptance. There must be two or more persons to an agreement because one person cannot enter into an agreement with himself. There must be two parties are required, offer and acceptance. Number two is intention to create legal relationship. The party must have intention to create legal relationship among them. If there is no such intention to create a legal relationship among the parties, there is no contract between them. Generally, the agreement of social agreement, domestic agreement, political nature are not a contract. We have to know that. There is a one case law, Balfour versus Balfour, in 1900. It is so important in case of valid contract to create intention to create legal relationship. We will understand. In this case, husband and wife live in Ceylon, both husband and wife. But during the holiday, they went to England, husband and wife. Mr. Balfour, wife, doctor recommended her to remain in England because the environment in Ceylon is unsuitable for her health. Therefore, while leaving, Mr. Balfour promised her wife to pay a monthly allowance till she come back to Ceylon. After some time, Mr. Balfour denied paying the money, and his wife filed a suit against him for breach of contract. When he failed to perform this promise, she brought an action to enforce it. यहाँ पर कोर्ट ने बोला, the court held that wife was not entitled to any money as there was no intention to create a legal relationship between the parties. There was no contract. कोर्ट ने बोला इन दोनों एग्रीमेंट जब्त किया, उस एग्रीमेंट जो है वो डोमेस्टिक नेचर है. There is no intention to create any legal relationship between them. The third essential element of valid contract is free consent of the parties. Consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake. Coercion means unlawfully detained. There is a criminal act involved. उसको धमकी देना. For example, in case of coercion, Mr. A ने धमकी दिया B को. If you do not sign in this paper, I will shoot you. In this case, there is no free consent because A ने धमकी देकर B sign लिया. the agreement is entered into under coercion and hence voidable at the options of B. Another example, for example, I asked you, will you buy my laptop for res 30,000? And you said, yes, I'll buy your laptop from you at res 30,000. There is a free consent. No one give a pressure to him. It is a free consent. But in case of coercion, it is not a free consent because someone given a pressure to him, there is a criminal. Number 2 is that undue influence. Undue influence, in case of undue influence, mentally pressure someone, unfair advantage. Number 3 is a fraud, धोखा देना. Damage ले सकता है in case of fraud. And number 4 is that misrepresentation, गलती से हुआ, misunderstanding. In case of misrepresentation, damage ले नहीं सकता. The last one is mistake. The 4 essential element of valid contract, that is competency or capacity of the parties to enter into contract. For a valid contract, the parties to the contract must be competent to contract. Section 11 of the Act provided every person is competent to contract, who is of the age of majority, sound mind, and not disqualified from contracting by any law to which he is subject. Therefore, law prohibits minor, persons of unsound mind, persons who are otherwise disqualified, like an alien, enemy, insolvent, convicted person, etc., from entering into any contract. There is one case law, it is very much important case law, that is Mohuri Bibi versus Darmudas Goose. I'm going to explain in another videos this case law. Minor agreement is not a contract in that case. So minor cannot enter into a contract. Alien enemy also cannot enter into a contract. Convicted person also cannot enter into a contract. There must be the age of majority, sound mind, and not disqualified by law. The 5 essential elements of valid contract, that is lawful consideration and lawful object. Consideration would generally means compensation for doing or omitting to do an act or deed. Something in return for another thing. Such a consideration should be lawful consideration. Consideration must be lawful, that is, it must not be forbidden by law or not be fraudulent. For example, in case of lawful consideration, A agreed to sell his house to B for 10,000. A ने उसका घर जो है B के पास बेचने के लिए वो एग्री हुआ. So rupees 10,000. Here B promised to pay the sums of 10,000 rupees is a consideration for A. Promise to sell the house and A promised to sell the house is the consideration for B. Promise to pay the 10,000 rupees. These are lawful consideration. The last essential element of valid contract, that is agreement not expressly declared to be void. The agreement which are not enforceable by the court of law will be declared void. They include like agreement with unlawful consideration and object, agreement having no consideration, agreement in restraint of trade, marriage, legal proceeding, wagering contract. See you in the next class. Thank you.